Welcome to Queen City News Plus Live. I am Brian Blakely.
And I'm Chief Legal Analyst Khalif Rhodes.
Khalif, always good to see you. We got court in session today. You know the deal. We always got three topics we're going to discuss legally. And the first one we're going to be discussing is the Supreme Court. It is a big time for them because this is where they start hearing all their new cases that are going to have some big landmark decisions going forward. And we do have a bunch of them.
Yeah, I mean, it depends on if the Supreme Court wants to take a big swing or take a small bite. That's the best way I can describe it, because we've been having big decisions before we got to this huge October docket, but they've been in the manner of this shadow docket, right, where folks are hearing cases on an emergency basis, where we're not getting opinions and the court's making decisions kind of fast to send things back to the lower courts. But what we haven't been having is full-fledged hearings on the merits. And so in October, yeah, we should have a number of them. A couple that I'm looking at is the case,
Villarreal out of Texas. Yeah.
That, exactly what you said. That's we're talking about. We have a constitutional protection, right, to a number of things as a defendant. But this one says whether a trial court may prohibit the defendant and his counsel from discussing the defendant's testimony during an overnight recess. This implicates the Sixth Amendment right to counsel. The issue was they were going on recess, and the attorney wanted to speak to his client. The court on the lower court said, no, you can't. You can't talk to them because you would unfairly persuade your client during that time. His attorney took issue with it, and his case has made it all the way up to the Supreme Court. I am interested to see what the court would say. I mean, typically, if I want to talk to my client that's not detained, I can go talk to him today and not have any trouble with that. But a client that is detained, that the court has jurisdiction and supervision of, there is a limitation on what I can do because they set those parameters. Additionally, if there's a recess, and so what I'm assuming happened is they were about to testify, then there's a time constraint or time limitation, and the court had to go to recess for that day and limited this ability to proceed right now. So then the attorney is saying, hey, I got a couple extra hours to talk to my client. Prosecutor saying, hey, this should have happened right now. You're unfairly giving him an opportunity to now interject and teach him and coach him on things that may have transgressed earlier in the trial. Those are the things that I'm assuming that the court is going to address here. But there are some major themes and talking points with this Supreme Court will address, even outside of that case. I've already talked about the shadow dockets, but this judicial attitude towards precedent, right? In law school, I was taught to respect precedent. We shepherdize cases. That's the process of finding a case and then looking to see how other courts have applied the laws and the rules that they talk about in that case moving forward. This court has been very skeptical, is the best way I could describe it, without stepping on toes, to respect and to appreciate precedent. Supreme Court Justice Clarence Thomas recently said that precedent should not be followed blindly, suggesting the court may be more willing to overturn or deeply reestablish cases. He even went on to say that precedent isn't gospel, basically saying that you don't have to follow it like it's something written out of the Bible.
Yeah, we've already seen that with Roe v. Wade.
We have, and this court's willingness to go back and look at things that other courts have done in the past is opening up the door for the rewriting of history in a number of capacities in how we move forward for the next 10, 20, 30, 40 years.
Some of those other cases that they're going to be talking about will be LGBTQ cases that have come up before the court where precedent has been set.
That will address it. And I mean, you talked about this before we got on. It's Chief Justice Roberts' 25th year anniversary, right?
20th year, yeah.
20th year anniversary. So during this time, the courts are known by who the chief is. You know, it's the Warren court, right? It's the Roberts court now. So during your tenure, it will either be known that you were a court that established new rules and or tore down old ones. And this rendition of the Supreme Court, for the most part, has not run away from tackling precedent. Limits on the executive power and agency independence. You're going to have the FTC, National Labor Relations, basically any independent agency that's out there. The president has attempted to say, I have authority over that. Well, historically, precedent-wise, courts have relayed on saying, yes, they're independent. This court, not so much. Freedom of speech versus regulation in sensitive context. You've had a number of things that folks have challenged their ability to speak. And most recently, with a number of things that have happened in the public eye, folks are being terminated for comments in public officials, in public capacities, typically where there would be protections for this speech. And the courts have attempted to now roll that back. You mentioned this LGBTQ voting rights, gerrymandering, racial classifications. I mean, there will be a number of cases that will be addressed on this October docket, but the overarching theme of the Roberts Court so far has been a mixed bag. It's been, consistently inconsistent is the best way I can describe it.
Okay, that's a good way to put it. But there's a couple other things that are going to be discussed as well. And we're talking about they're scheduled to meet in private, as you were talking about some part of the quick emergency cases that they're hearing. One of those is to discuss the appeals that have piled up during the summer recess, one including Ghislaine Maxwell and her challenge to criminal convictions for recruiting and grooming teenage girls for Jeffrey Epstein. Epstein's still in the news and continues to be a bugaboo here for the Trump administration.
He is. And I mean, if you think about it, Maxwell, the Congress wanted her to come and testify. Her legal team, rightfully so, said, hey, before we can come and testify, we're going to need some immunity. Well, why did they need immunity? Because they have this pending matter before the Supreme Court. These are the types of things where if you're a good lawyer, you don't drop the ball. You'll ensure that you protect your client as you move forward in this process. But not only are they talking about her case, they're talking about a number of double jeopardy protections that are put in place and how you have direct consequences from being having overlapping firearm statutes and stacked against you in different types of courts and how they interpret that. So I am looking at a within this session alone, and I have been surprised a number of times, but I'm looking at a large amount of cases in this October session that will impact so many different areas from our social impact, from our criminal justice impact, and from just how the courts in all three branches, co-equal branches of our government are supposed to interact.
And the other thing that they're putting on the accelerated track here is the oral arguments of the first week of November. That is resolve the issue about Trump's executive powers when it comes to like tariffs and imposing those around the world.
Yeah, and you're going to have that conversation on tariffs because this is something that a number of lower courts have said is unconstitutional. And I talk about this a number of times here when we say what is the president's ability to do certain things. And when is the Supreme Court's responsibility to step in? Now, the president has an authority and has a number of attorneys around him that will find ways for him to get to where he's trying to go. If he's like most of the clients that I've ever had, hey, I want to go straight. Give me the case law that supports me going straight. And they may not say it in that capacity, but that's what they're trying to do. So in this regard, with these tariffs, he was using these emergency protections, right? What's the emergency? Well, it's foreign adversaries to an American first policy. If I'm attempting to say I want to ensure Americans have better jobs and they're producing better products, and these outside agencies and outside companies are interfering with that, hey, there I have my emergency. Well, lower courts have said, no, that's not the emergency that law was anticipated to protect. And so you have a number of courts that have ruled against him. Then you get these Court of Appeals decisions that rule against him in some jurisdictions and rule for him in others. So when you have a conflict, right, a conflict of decisions, and you have, competing decisions from lower courts, oftentimes that's when the Supreme Court is going to step in. The other issue when it's constitutional. So this isn't a constitutional question. This is more a conflict question. Does the president have the authority to do this? And have you had conflicting opinions from courts on the same level? And so while at the same time you're doing that, you've already got this mixed guidance from the Supreme Court about how lower courts, inferior courts, U.S. district courts should handle these injunctions. And so now they've opened up Pandora's box for what I anticipate will be a flood of class action suits. Because if now I can't get a nationwide injunction by filing one claim, I'll get 100, 200, 300 folks that are similarly situated and file a nationwide claim. So I still get to the end result. That same solution that the president is attempting to have, also a plaintiff can do by saying, I want to find a way to get this nationwide injunction. I just can't bring the claim on my own. Go find some like folks that can do this with us.
Yeah, and the other case that they're looking at, too, is the firing of the FTC commissioner, Rebecca Slaughter, too. That's challenging the president's authority to fire her. So that falls under the same thing about the president's authority and the Supreme Court is going to hear.
Those limits on the executive power this is going to shape how the president is an executive and how they can govern, for better, lack of a better term, for the next 5 or 6 presidencies. This Supreme Court will lay the foundation that will dictate the next president. And the word of caution to the Republican Party is that while doing this, while you may have all the folks down, oftentimes what happens is the party that's in a position of power loses power, and then the party that takes over utilizes the very things that power that other party put into place. So in scenario, if the Supreme Court decides to expand the powers of the presidency, well, it looks good today, but going forward, as you have multiple elections, at some point, there'll be a Democratic president in office utilizing the very power that this Supreme Court is now giving and strengthening and expanding for this executive branch. And so the word of caution is that it may be happy today, but years later, this may have devastating consequences on how we operate as a country.
All right, we're going to leave that one there for our first topic today. And so certainly we're going to keep following that, especially over the next couple of weeks when they start hearing these cases. We'll get a little bit more information as those arguments start to come out with the Supreme Court. Chief Legal Analyst Khalif Rhodes. When we come back, we're going to be talking about AI and mental health and behavioral health, those two worlds colliding on the next segment. You're watching Queen City News Plus and Order in the Court. We'll be right back. Welcome back to Order in the Court with Brian Blakely and Chief Legal Analyst Khalif Rhodes. Second topic of the day, Khalif. Let's talk about something we've talked about, you and I, Quinn.
Yes.
And that is artificial intelligence. And now the legal case that comes up out of this, Illinois signed into law that they cannot provide any kind of internet-based artificial intelligence when it comes to behavioral therapy.
Yeah, AI is attempting to peek its, I won't say ugly head, but its sneaky head into everything. And it's all around us, right? AI was around us before we knew that it was around us. The only thing that happened is OpenAI and the other type of companies that were out there have been marketing now to mainstream. But these types of products, this generated type of learning, this mass, information learning models that are placed out there that's taking, huge amounts of data and then spitting out information in, record time, that's been around for years. The issue is now, mainstream individuals are utilizing it. And some are for good, and some may not be for good. Yes, and so
especially when it comes to like behavioral and mental health here.
Well, you got to think about what's happening, right? You have these mass learning algorithms, these things where you're dumping a lot of books and information and anything that's on the internet and all into one, platform, and then that platform is taking that data and then attempting to utilize it, for whatever this could be. And so in this scenario, it's for mental health communication, using AI chatbots for treatment decisions or client communications, recommending chatbot therapy tools as a replacement for traditional therapy. And this is violation of this law in Illinois is up to $10,000 penalty for a violation. But this is a restriction. Why? Because someone saw a entrepreneurial benefit, a need there. It existed as well. So when you take a need and demand and supply and demand, bring them together, normally you can make money off of it. But who gets hurt in the middle? I mean, what comes to mind is that Florida teen that took his own life, falling in love with the Game of Thrones character. The Texas teen that had the chatbot that encouraged him to commit self-harm to their autistic son. Those are the types of things that I think about when you're talking about mental health and you're saying AI, people exploiting it for gain, while the individual end users may not be utilizing it in the method that they anticipate. So this is Illinois, the third state in the country, taking the opportunity to say, hey, we're going to try to protect our citizens before this gets out of hand. I often say that we are reactive as a community regarding laws and rules, but this is at least their attempt to try to be proactive before multiple individuals get harmed from something like this, man.
We've seen this too, like with the internet overall over the past 30 years. It's taken a long time to find some sort of regulatory footing of any kind. And then now with AI, it seems like, this is the Wild Wild West. It's a new game in town, and people have to figure out. Well, that's why we have to react to it. Yes, being proactive. You can't see some of the things that are
you can
ahead of you.
But a lot of the writing was on the wall for these types of things over the years, especially in the legal landscape. I remember working in document review years ago, and that's where you go over discovery, multiple millions of sheets, sometimes audio files, sometimes video files, but most of the time it's going through paper files and it's on the computer. And you're most of the time it's new attorneys that have not had much legal training, but are attempting to get their foot set in the legal landscape. And so you're doing this to document review, and in the process, you're reading hours worth of data, hours and hours worth of data. And companies are trying to find a way shortcut attorneys out of there, right? So the requirement, if you're looking at legal discovery, is that you have a legal mind looking at it. So what were companies doing? I can take all these documents, scan them into the system, and let a computer go in there and look for the very things that I could pay a human to go find. And I remember a California court said during that time, this was probably 20 years ago now, that, listen, we still will need even the modicum, like the smallest amount of human oversight, human eyes looking at it. Why? Because you as the human, you as the attorney will be able to utilize your logic, your analytical reasoning, but then also your human ability that a computer cannot do to be able to decipher the things that you're reading. And so the same thing here. I looked at this Stanford study that talked about many chatbots failed to detect concerning prompts, like finding places to jump off a high bridge. Well, if you start asking me, Brian, hey, what's the best place I could jump off a bridge in Charlotte? As a human, I'd say, well, Brian, what are you trying to do? I wouldn't automatically go and try to find, based on the height, the highest bridge without taking into account what does he want to use that bridge for, right? Yeah. But see, these chatbots aren't doing that. And that's what the courts have held is the problem with attempting to utilize them in discovery. That's also what Illinois is saying they find is the issue with attempting to utilize them in mental health. If you're just spitting out the facts that you pulled from one or two books, you've taken the human element out, which oftentimes goes outside of what the books say or require.
And just to clarify on what this Illinois Act does and does not do, it says when a licensed professional is involved, AI may not, 1, make independent therapeutic decisions, engage directly in therapeutic communication with clients, 3, generate treatment plans or recommendations without licensed professional review and approval, and 4, detect emotions or mental states here, which is exactly what.
And it's just like the legal profession, right? You got these companies that come in, like that are offering legal services, but there's no attorney involved, and all they're doing is, generating forms. And you had a number of attorneys general filed lawsuits in states saying, hey, you guys don't have a footprint in our state. You don't have an attorney connected to that business in our state, but yet you're utilizing and offering legal services in our state. And there's no human interaction, no licensed person in our state doing it. This is the same capacity. They're not saying you can't utilize AI. It just needs to be under the supervision of a licensed attorney. And I can imagine the reason why is because you're seeing, again, that supply and demand. You have folks trying to find a way to get a product in a user's hand as quick as possible and get access to the funds that user has in their hands. If I can pay a subscription fee to get, therapy from an AI that's $20, not have to go pay for a $200 session with a therapist, most of the time an end user is going to pick that. The client's going to say, let me find a cheaper version. I was actually watching a show recently, and they made a joke of it, but it was pretty real. The mom said, well, hey, I've been texting with my therapist. And what did she say? Because this is cheaper than going to a real office. Now, she wasn't texting an AI bot, but that was already a service that was implemented and because of cost. Think about it. 40 years ago, Brian, 50 years ago, would she been able to text her therapist? No. Because text wasn't even a big thing, right? Now, fast forward to text is something that we utilize on a routine basis, super frequent. So now, instead of me going to the office, I can text, and instead of me having a 10 times the amount of the bill, it could be lower. AI is the next integration to that, cheaper, faster, more affordable. But if you're removing the human element, I think the law, and I've been supported by the case law that's out there so far, is going to say it's going to be problematic.
All right, we're going to leave that one right there for right now. But when we come back, we're going to be talking about another topic that's been in the news too, and that is about immigration. And we do have another case out of Cincinnati involving an imam there. And we'll have that when we come back right after the break. You're watching Order in the Court on Queen City News Plus Live with Khalif and Brian. Welcome back to Order in the Court. You got Khalif and Brian here talking about our third topic of discussion here for our legal topics. Khalif, we have talked about the Supreme Court. We have talked about AI. Tonight, right now, we're going to talk about another one of those topics that we've always seemed to have a lot of legal issues regarding, and that is immigration, and that is the detainee of an imam that happened in Cincinnati.
This is a crazy case. I typically like to go through when I'm trying to review items, I want to know the who, what, where, and why, right? So we're talking about where is Cincinnati. The who is this Solomon, Egyptian-born
Imam
imam.
Solomon, yeah, right.
Right. in a hospital chaplain in Cincinnati. The what? He was detained. But let's give the background on the what. Came to the United States in 2014 from Egypt, was granted asylum in 2018. In December 2024, he was notified that his asylum status was under reconsideration, and in June 2025, his asylum was reportedly revoked. So on July 9th, in a routine ICE check-in in Ohio, he was detained. And when he spoke to the officer there, this is the troubling red flag. When he spoke to the officer there, the officer told him, and this is his words, that I'm sorry that I have to arrest you. He said, because we were just notified that anyone that comes to this location for a check with ICE has to be arrested today. Not because of a violation, not because they've done something that was, in violation of the rules or, that they should be removed instantly. But no, you should be violated because you've just come and done the very thing that the Trump administration says you should do. That during the campaign promise, we're not going to fight folks that have come here legally. This guy right here, 2014, that's legally. Granted asylum in 18, legally. But yet now somehow in 2025, we need to go ahead and remove you for something other than just being here. Held in Butler County Jail. I've been to that location in Cincinnati, learning a number of things when I was in that area. He reported harsh conditions. And this is what I want to try to talk about, is that we have to remember, if we're going to say we're having the largest deportation in American history, we have to recognize that we don't want to commit humanitarian violations while in the process of attempting to do this, regardless of what side of the aisle you're on. If you're saying, hey, I'm in favor of mass deporting hundreds and thousands of people, we don't want to go and look back in history and say we were the country that not just separated kids, because that was the issue during the last administration where folks say we don't want to do that. But no, that we treated these detainees like criminals, like they were inmates.
Yeah.
And that's what the cause and the concern has been.
We've known that is even from Charlotte as well, from the detainees from the Kings Mountain raid. A lot of them were held in the Charlotte location, and we understand that they were housed in pretty deplorable conditions there with overcrowding. They were not prepared to handle them to come into that jail.
And most jails are not going to be
or that immigration facility, I should say.
Right. Most locations are not going to be ready and trained for this because this is all new. Locations where you may have 10 or 20 people are now hundreds of folks are going to be there. So food is going to be scarce. He talked about being in a room for 12 hours, ice cold with a T-shirt on, rusted bed, in a room with 15 people trying to use one restroom. To me, that sounds like an intake hole in a jail because I've seen enough.
Legally, what can you do about that, though?
Typically you want to have an attorney like he did, multiple attorneys fighting on his behalf to be sure that he can have another hearing to determine if he actually should.
Meantime, 3 months there, he lost his job as a worker at a hospital, as a chaplain at a hospital.
Lost his job, and other people that came to his support lost his job for speaking out. So the first thing you can do is have resources or be in touch with organizations that have resources to fight your fight. And the problem is, and he said this, the difference between me and the other folks that are still there is I had people that supported me, that loved me, and had the money to help me get out of there. Money, i.e., they can go file hearings, that can file, injunctions to stop this individual from leaving. If he is granted asylum, right, that doesn't mean he came here on vacation. He came here on asylum because he was fleeing persecution, that in his country that he left, they were attempting to kill him. So those are the types of things that you would want an individual to go, an attorney, I should say, go and plead your case in front of a judge. But he also brings up this. I think he did an excellent job of summarizing the entire issue. He says, well, if the administration is removing immigration judges, right, and they're denying and removing individuals of attempt and ability to have immigration hearings, then they can remove me anytime they want, because then they could just say there's not enough time to have a hearing, and before I know it, I'm gone. That erosion of the process, of the legal system, it is not just eroding the trust, but it's literally eroding the process. And we do have a process in place. When a person's status has been checked or challenged, they have an opportunity to go and defend themselves as to why the status hasn't changed and why it should be there.
He has been released, and he's expected to have his visa status fully returned to him as the resolution out of this case.
Public outcry in this community. I think it was the perfect storm. Working in a hospital that got attention. He had coworkers that supported him that brought attention, and legal experts that were working in his corner. I mean, that This case right here is the example of what we don't want to have, that people have come here and attempted to flee for their safety, come to the bright lights of America with dreams and opportunity and hope, and then be almost turned away back to the very place that would not presumptively kill him, but would guaranteed to kill him. Those are the types of things that aren't just numbers on a paper, that aren't just, Excel sheets of saying, hey, we removed this many this week. But these are conditions and concerns that we're going to have to deal with for lifetimes. Equal protection of religion, I think, is probably the biggest challenge. If you're saying, hey, he was in jail in detention, requesting to pray. And the guy told him, the officer said, go and pray right there where they're playing basketball on the court. Well, there's constitutional protections for folks to be able to have an opportunity equally to go pray in the same places as Christians would do. And so those are the types of things that I think, Brian, that this case bring up, and the consequences for these actions won't be addressed for years.
We will certainly keep shedding a light on it, as we have 3 topics today. Chief Legal Analyst Khalid Rhodes, always appreciate you and your insight and also expertise, buddy. Enjoyed it. As always, a great discussion here, and you've been watching Order in the Court here on Queen City News Plus.
Queen City News Plus. Just search Queen City News on your smart TV's app store.